I, Shishir Yadav, welcome you all on behalf of the Faculty of Law, University of Lucknow. Today, this is our last session of the three-day webinar series on impact of COVID-19 on international law. Now, I welcome Dr. Bhanu Pratap, Assistant Professor of Faculty of Law, University of Lucknow.
Good evening, everyone. Today, I'll be discussing two topics, rather two themes of the seminar: the impact of coronavirus and international law, and the impact of coronavirus on international relations. Now, before we proceed with the two themes, let me apprise the audience that this situation is unique. Such an event has never occurred in our lifetime. So most of the discussions that we are going to have right now for the next 1 hour, I must serve the audience with a caveat that most of the argument that I'm going to give in my presentation is hypothetical. It has not happened yet because of the unique situation that we are facing, but it will rather be my endeavor, rather it will be our endeavor to understand the impact of this pandemic on our lives and how it has affected one of the most important streams of law, that is international law. Now, the reason why we have chosen international law amongst the various streams of law is the situation that we are facing, or some of the terms that have made their way into our normal day parlance, such as social distancing and quarantine and isolations. All of them are coming from international law. So it is imperative upon us to understand how a pandemic is affecting our daily lives and how international law is playing a leading role. Now, I would like to start my discussion on the impact of coronavirus on international law with a very smart observation. This observation has been made by various jurists, and the observation is about the existence of international law, which unfortunately is not taken seriously by legal scholars and the universities all around India. So the quotation goes something like this: that once a fish told another fish that, do you know that we are surrounded by an entity called water? Rather, we live in an entity called water. The other fish, to whom this question was addressed, started looking around and said, where is this water? Similarly, we can say that we are surrounded by this web of international law. And in the same way, just as the fish was not able to locate water in spite of water being present all around her, we still do not realize the importance of international law, which is everywhere. Its presence is wider than criminal law and constitutional law combined together. Now, when we see the impact of coronavirus on international law, we are going to see that not only is it international law that is governing our daily to daily life amidst the pandemic crisis, we will see as to how our epistemic change in understanding international law, in understanding its intricacy, are we in a better position to reflect on our own existence, our own unique existence in these unique times. So, in order to understand the situation or everything that is happening around us, be it the quarantine or being the isolation, social distancing, we have to understand that this everything is happening in an international perspective, or everything is happening in a global perspective. So, how did we reach here? How did we reach today? How have we reached a situation that we are interacting with each other through webinars, through cybernetic means instead of one on one interaction? Now, as far as coronavirus and international law is concerned, in this discussion, we'll have a brief introduction to the functions and powers of World Health Organization. Secondly, we'll see something about state responsibility and coronavirus. And third, we are going to discuss uh, a very unique situation that is being discussed all over the news channels and social media as to which country is responsible for the outbreak of this virus, and if a particular country is responsible, what are the legal measures that are available to us. So these three topics will be covered under the theme of coronavirus and international law. And lastly, we'll sum up as to how coronavirus is going to change the international relations or the world around us. Now, World Health Organization is arguably one of the most profound and one of the most serious international organizations that we have. The onus that lies on World Health Organization is very serious, and its existence is very much relevant these days. Now, being the students of international law, we must understand that international law as such is operating in a decentralized scenario. When we talk about international law or the nature of international law, we must understand that it is very much different from municipal law. It is not vertical in nature like a municipal law. It is horizontal in nature, and it is decentralized in nature, and there is an absence of hierarchy of norms in international law. So, in a nutshell, we do not have a world sovereign, we do not have a world legislature, we do not have a world executive, we do not have a world judiciary. So, we have a system where there is no centralized hierarchical system which can implement the law. So it is in this structure that we have to understand coronavirus and its impact of international law and the role that state, international organizations, and individuals are playing. Now, as far as the pandemic is concerned, pandemic is affecting all the three subjects of international law. The three subjects of international law being state, individual, and international organizations. And if we look at international law, then in addition to state, it is the international organization that are playing a leading role in combating coronavirus. And how is this happening? This is happening because of the presence of an organization called World Health Organization. Now, before the World Health Organization came into being, there was another international organization that was dealing with the same issues which WHO is dealing with, but it was a regional organization called PAHO, Pan American Health Organization. Now, when the World Health Organization came into being, it superseded all the activities and functions of a Pan American Health Organization and became the central organ or the central institution which was concerned with the problems of pandemics, epidemics, and diseases all around the world. Now, World Health Organization came up with something that is called International Health Regulations. Now, international health regulations, they were issued in the year 2005 and they were brought into being in the year 2007. Now, if you look at the constitution of World Health Organization, it is very unique. Article 21 and Article 22 of World Health Organization clearly states that World Health Organization has the competence to issue regulations binding for all the member states without national ratification procedure. That means irrespective of the fact whether any country has ratified the WHO constitution or not, World Health Organization has the competence to issue certain regulations which are binding on the member states irrespective of the fact whether they have ratified the WHO constitution or not. This is a rarity because, as most of you must be knowing, that an international treaty is not binding upon a state until and unless a state has given its consent to it, and this consent is presented in various forms: in form of signature, in form of signature, in form of ratification, in form of accession. But all these methods which have been covered under Article Vienna Convention of Law of Treaties, the process of ratification as such is irrelevant for WHO to bring its regulations into force. Now, by invoking the power of Article 21 of the WHO Constitution, World Health Organization enacted the International Health Restricted Guidelines. And these international health regulations, they came into 2007, as I just mentioned. Now, these are very exhaustive in nature, composing of 66 articles and 9 annexures and 2 appendices. Now, if we look at the articles or the main law governing international health regulation, we will be in a better position to reflect as to how the world community, the international community, the state actors are trying to combat this coronavirus. Now, terms like quarantine, isolation, and the various security checks that you see at airports and railway stations, all these directions have been given under international health regulations of 2005, and everything is being administered by World Health Organization. So being students of law, being students of international law, it is imperative upon us to be familiar with the law that has allowed us to combat coronavirus, to fight coronavirus, or to fight a pandemic, as the thing goes. So, in a nutshell, whatever we have been seeing, whatever structure has been presented before us, whatever new way of life that we are leading is very much connected with international law. Now, if we look at the international health uh, regulations, and if we see the Article 2 of international health regulation, it clearly says that the purpose of bringing forth the international health regulations is to prevent, protect, control, and provide a public health response to international spread of disease. So the situation is very clear that by virtue of Article 21 and 22 of World Health Organization Constitution, international health regulations have been created, and these international health regulations under Article 2 are laying down a specific purpose of these regulations, and the purpose is to create a unique mechanism of public health response to international spread of disease. Now, WHO as such does not have a mechanism of its own through which it can collect data about the extent of the pandemic in a particular country. So, since it does not have its own resources, it relies on the states, on the signatory states or the members of World Health Organization to collect the data regarding the spread of pandemics all around the world or in a particular country. And this situation is given under Article 4 of International Health Regulation 2005. So that's how you can see, you must be seeing it in the news channels that such and such country has provided such and such data to World Health Organization as to how many victims of corona virus are present in a particular country. So this is being done through Article 4 of the World Health Organization. Now, Article 6 is of utter importance for all of us. Article 6 says that the member state of World Health Organization shall notify the World Health Organization within 24 hours if there has been constituted a public health emergency. So if the situation is alarming, if the situation is reaching where World Health Organization has to declare a particular disease as a pandemic, then a particular country has a duty to do so under Article 6. You have to give a 24 prior notice to the World Health Organization that the situation is worse, that you have to declare it a pandemic. Now, it is by virtue of Article 6 that United States of America started blaming China, that China ignored or did not care to report the matter to World Health Organization, or they were complacent in reporting the worsened situation in Wuhan, China. So China should have followed the legal obligations as given under Article 6. And Article 6 goes on to state a very important point of law. It goes on to state that missing, deleted, or not fully reliable information is not just a misfortune, but a legal issue. So if the member states is delayed or is not being very active, or it is getting a delayed response in reporting a particular disease that has assumed the scale of pandemic to World Health Organization, then it is simply not a matter of negligence. It is a matter of legal obligations. It is a matter of legal issue. So legal obligations arise if you fail to report the worsened situation under Article 6 of International Health Relation. Now, Article 9 presents a unique situation before us. According to Article 9, the World Health Organization should take into account not only the official report of the member state, but also other reports while assessing the impact of pandemic in a particular country. So what is important here is that WHO should not only take into account the government report, but any other unofficial report through which truth can be reflected. Now, as most of us know, that China is trying to hide the actual data or the actual extent of the coronavirus in Wuhan and other provinces. So the World Health Organization can also rely on some of the declarations that have been made by the doctors or some of the scientists on social media or other platforms. Even that can be taken into account to assess the real situation. Now, Article 10 lays a duty on the member states, and they have to verify the data that they have given under Article 9. And now comes the next important article or the next important law in the international health regulations, and that is Article 18. Now, Article 18 is very important for us because this is the particular article that is responsible for infusing or importing certain new words into our daily language. Words like social distancing, screening, contact tracing. All these methods are given under Article 18 of International Health Regulations, and these methods are thereby adopted by member states to fight a pandemic. So everything that we hear today is given under the World Health Organization constitute either the World Health Organization or International Health Regulations. Article 1 of International Health Regulation goes on to state two terms that have become very popular recently, and that is quarantine and isolation. Quarantine is different from isolation. Quarantine is done whenever there is a doubt that a person might be infected with coronavirus, or particular locality might be infected with the coronavirus. But when the situation is confirmed, then quarantine ends and the concerned people or the concerned area is put into isolation. So quarantine precedes isolation as per Article 1 of International Health Regulations. Now, next important articles that we should have a look at are Article 31 and Article 32. Article 31 clearly states that the travelers who are present in a particular nation state or who are present in a particular country, they are subject to go through a series of vaccinations and examinations by the particular country. So everything that we are seeing at airports, at railways, as bus stations, all this is coming from international health regulations. And Article 32 clearly states that while these passengers or tourists or travelers are being examined under Article 31, then the concerned government or member state should take due regards of their human rights. So Article 32 is trying to create a bridge between the law of pandemic and human right considerations. Article 40 of International Health Regulations states a very unique idea that the travelers are not going to pay for the health measures that are being provided. So it is a responsibility of the state where they're being treated to take care of their uh, health and other well-being. So you cannot charge the travelers for their health measures. Now, as far as Article 56 Article 56 of International Health Regulation is concerned, it is very important from the procedural point of view of international law. Article 56 talks about the dispute settlement procedure given under international health regulations and the World Health Organization. The dispute settlement mechanism says that if there is a dispute among the member states regarding the law of World Health Organization, they should first resort to arbitration as constituted by Permanent Court of Arbitration. So first they have to go to Permanent Court of Arbitration. If that doesn't work, they can approach the World Health Assembly, and if that is not possible, then other judicial organs are also open for them. So it is clear that Article 56 is following the principle of subsidiarity. The principle of subsidiarity, as given under international law, clearly says that you should not approach the center of the power first. First, exhaust your local remedies that are present at the lower level of the power. So first, you go for arbitration. If that doesn't work, you go to the World Health Assembly. And if that doesn't work, you have the option to go to other organs, namely International Court of Justice. Now, how is WHO working? How do we know that a situation has reached to the level of being labeled as pandemic? This is being governed by Article 12 of World Health Organization. Now, under Article 12, WHO director has the power to declare something that is called public health emergency of international concern. So under Article 12, it is the power of the director of WHO, to declare a particular disease as a pandemic. And when the director is of the view that a particular disease should be declared as a pandemic, he convenes an emergency committee. He summons an emergency committee under Article 48, and by consulting that emergency committee, it goes on to declare a particular disease as a pandemic. Now, so far, I'll just read out the list of the diseases that have been declared as public health emergency of international concern. The first one being the H1N1 influenza, and it was declared a pandemic on 24th April 2009, and the date ended on 10th August 2010. Then the second pandemic was the Will polio virus, which was declared a pandemic on 5th May 2014, and it is still active. And 2014 to 2016, we saw the outbreak of West African Ebola that was declared a pandemic, and it was declared a pandemic on 8th August 2014, and it ceased to be a pandemic on 29th March 2016. Then comes the turn of the famous, rather infamous Zika outbreak. It was declared a pandemic on 1st Feb 2016, and the situation came under control in 23rd no, on 23rd November 2016. Then the Ebola, which became a pandemic in Democratic Republic of Congo, and it was declared a pandemic on 17 July 2019, and the situation has still not brought under control. And the last being the corona or COVID-19 virus, which was declared a pandemic by WHO on 30th January 2020, and the situation still has not been brought under control. So you can see that by combination of Article 12 and Article 48, the pandemics are declared, and this is the status of all the pandemics that have occurred in the last 10 or 11 years. Now, as far as the World Health Organization and international health regulations are concerned, they are also connected with the human rights issues as given under International Covenant on Civil and Political Rights. As I've already mentioned, Article 32 of International Health Regulation clearly states that while uh, giving vaccinations and other preventive examinations to the travelers, their human rights concern must be respected. And European Court of Human Rights. The European Court of Human Rights has given very progressive judgments, and they have said that if measures are being taken under international health regulations and World Health Organizations, so if isolation measures and quarantine measures are being taken, then they will not be deemed as a violation of the international human rights or ICCPR. Now, as far as the Rio Declaration is concerned, Rio Declaration in its principle 15 has clearly stated that a lack of full scientific certainty shall not be used as a reason for postponing cost effective measures to prevent environmental degradation. Now, if incorporated into the law of World Health Organization, this clearly means that a state cannot take an excuse that it does not have full scientific uh, infrastructure to fight the pandemic, and it has to incorporate the WHO measures into its legal regulations. Now, if we look at the entire system of World Health Organization according and along with international health regulation, there have been certain voices which are saying that a particular country is responsible for the outbreak of coronavirus and it should be held accountable at an international level. So let us see as to which law we can resort to in order to assess whether a particular country is responsible for outbreak of coronavirus and what are the legal remedies available to us. Now, as I've already stated, this is a very unique situation. Such a situation has never occurred in our lifetime. So, in order to assess or in order to find out as to whether a particular country is responsible for the outbreak of coronavirus, and if it is responsible, how can the international legal mechanism respond to it? Now, if we are saying that, let's say, China is responsible for the outbreak of coronavirus, and if we have to allow international legal mechanism to kick in order to assess the responsibility of China in international law, then the concerned law is law of state responsibility. Now, state responsibility is one of the main fodders of international law, one of the outstanding features of international law. When we talk about state responsibility is the law that simply decides that one state has a number of legal obligations against other states. And if the particular state breaks those legal obligations, then it is accountable in international law, and the other state whose legal obligations have been breached is allowed to sue the particular state before an appropriate international judicial forum. So the concerned law is law of state responsibility, and it is incorporated under the ILC draft on state responsibility. The International Law Commission draft on state responsibility has incorporated the entire customary as well as treaty law of state responsibility under one document. Now, let me remind you that ILC draft on state responsibility is not a treaty per se, but it has incorporated the customary law related to state responsibility as to when one state can be held accountable to the another state for breaking certain international legal obligations. So it is a reflection of customary international law, and hence it is still a valid law. Now, when we talk about the ILC draft on international law, we have to take certain things into account. Number one, ILC draft on state responsibility is only applicable when one state is not able to deliver or not able to deliver on its legal promises. When we talk about state responsibility, then we do not consider a situation where a state can be held responsible for the act of its citizens. That is not applicable. So, when we talk about state responsibility, we are talking about legal obligations. There has to be an existence of an international legal obligations, and if there is a breach of this of those international legal obligations, then the law of state responsibility follows. Now, as far as the law of international responsibility is concerned, we have to see two things. Number one, we have to see whether the particular violation of international law can be attributed to the state. Or, in other words, we are talking about something that is called doctrine of attribution. Whether the violation of a prior existing international legal obligation can be attributed to one of the organs of the state. Now, this law can be is covered under Article 4, 5, 6, 7, 8, 9, 10, and 11 of ILC draft on state responsibility. Now, when we talk about the organs of government, we are necessarily dealing with legislature, executive, and judiciary. And the ILC draft on state responsibility is not only limited to legislature, executive, and judiciary, it is also applicable on private actors, provided these private actors or non-governmental organization or private military corporations are performing all the functions that have been entrusted to it by the government. So Article 4 to 11 is covering the organs, be it legislature, executive, judiciary, or any private body which has been given the legal actions or legal power by one of the organs of the government. Article 7 says that even if an act is ultra virus in nature, even in that situation, state responsibility will be applicable. Now, when we are talking about state responsibility, many of the countries have issued a force majeure certificates to the particular trading companies. Now, as all of us know, that most of the countries are having the nation, two nations, or two governments, or two private companies are having business with each other. Now, because of the immobility of the economy, most of the countries have issued something that is called force majeure certificates. That means whatever trade negotiations or trade treaties have taken between them, they will come to a halt. Now, is this applicable? Can one state say that no, you are going back on your words, and this particular country whose contract is not being honored, it will sue the other country before an appropriate international judicial forum? Can that happen? If that can happen, then can the other country who has issued a force majeure certificate of non-performance of a contract, can that take some sort of exception? Can that take a defense? That defense is available under Article 23, 24, and 25 of ILC draft on state responsibility. Article 23 is talking about the doctrine of force majeure. Article 24 is talking about the situation of distress, and Article 25 is giving the exception of necessity. Now, force majeure, as I had already mentioned, that some countries have issued the certificate of force majeure. Force majeure simply means that there has arisen an unforeseen circumstances where there is an irresistible force which is not allowing a particular member state to perform its contractual obligations, and there is a material impossibility that it cannot honor its treaty obligations. So force majeure is one of the defenses, that because of the outbreak of coronavirus, we are not able to perform our contractual obligations. Now, what does force majeure mean? Force majeure means that situations that are beyond your reach, something that state could not control, something that state could not anticipate. So force majeure is primarily based on two things: that there was occurrence of an irresistible force. Irresistible force means that the states were compelled. They were compelled and they were completely helpless in a particular situation. They could not do anything. The situation was out of their hand. And this, why this situation happened? Because of certain unforeseen circumstances. Now, unforeseen circumstances, as we clearly know, no one could have predicted a pandemic. And as far as force majeure is concerned, it is not applicable if the plaintiff itself is the wrongdoer, or if the plaintiff itself has consented to a particular act. So if a country is resorting to the defense of force majeure, it will fail if the country itself was the wrongdoer, or if the country itself has consented itself to a particular harm. But force majeure is very difficult to prove in the court, because force majeure is strictly interpreted. It is very difficult to prove a force majeure, and only a handful of cases have succeeded so far. So if a country is resorting to force majeure, it's not a very sound strategy. Next come Article 25, the doctrine of necessity. Now, necessity says, Article 25 clearly states that necessity shall not be taken as a defense until unless there is some grave imperil. Grave imperil means that the situation is very risky, this situation that could not have been assessed. And just like force majeure, necessity is strictly interpreted, and it does not have a very high success rate when pleaded before an international judicial forum. So necessity as such has not been able to save the people, save a particular country from not complying with its treaty obligations. So the best option that is available before a country for not following this treaty obligations amongst the coronavirus is that situation of distress. Article 24. Now, distress is a particular application of necessity. Necessity is general in nature, and distress is having a limited approach, and distress is applicable where a state is trying to avert a bigger crisis, and in order to avert the bigger crisis, it is trying not to go head to head with a smaller crisis. So in order to prevent a bigger crisis, you are not following your treaty obligations. And it is the essence of Article 24 that distress, the law of distress, has been specifically designed by ILC so that it can deal with those situations where the lives of the citizens of a state are at risk. And same is the situation here. If we have to create an organic relation between the government and the people, the most viable option present before a member state is that of distress. The particular member state can clearly say that we were trying to protect the lives of our citizens, and that is why we put a halt to all our treaty obligation, to all our commercial obligation, because the saving lives of millions and billions of our people was more important for us. If you want, you can compare the same. You can compare the same article with Section 81 of IPC, where in order to prevent a larger harm, you are allowed to do a smaller evil. In order to prevent a larger evil, you can resort to the completion of a smaller evil. So that is the law that is present before uh, the Article 24 of ILC draft on state responsibility. Now, coming to the liability of China. Should China be held accountable for the outbreak of coronavirus? Now, this is a very tricky situation. Again, the answer that is being propounded is completely hypothetical so far. We don't know what the legal situation will be once the lockdowns are over. Now, in order to hold China accountable, it will be very difficult to prove that the outbreak of coronavirus was a man-made activity and it happened in the laboratory of Wuhan. Now, uh, what laws has China broken? As I've already mentioned, Article 6 and Article 7 of World Health Organization of International Health Regulation, that it failed to provide information uh, to the World Health Organization. It can also be argued that China, if responsible for the outbreak of the coronavirus, has broken the law as given under Article 18 of Vienna Convention of Law of Treaties of 1969. We can say that by not fulfilling its obligations under Article 6 and Article 7 of International Health Regulation, China has violated the very essence of the World Health Organization Treaty and International Health Regulation, and that is given under Article 18 of Vienna Convention of Law of Treaties, where it is clearly said that member states shall not do acts which will go on to frustrate the very essence of a treaty. Now, if we have to see deeper, then Article 64 of the WHO Constitution clearly states that statistics must be in regulation with nomenclature regulations. Again, China has failed to provide the adequate numbers. And even if now, if we say that if China were to held accountable, then where exactly can we go? The situations are very limited. Number one, either we can resort to arbitration, and it is very highly unlikely that China will give its consent to go for arbitration in this matter. The second option that we have, and something that is being discussed vigorously by scholars all around the world, does International Court of Justice has any sort of jurisdiction over it? Again, the answer is very skeptical. Particularly, I'm very skeptical about this, because in order for International Court of Justice to assume jurisdiction over China, it is very important that International Court of Justice has jurisdiction over it. Now, under international law, and especially under Charter of United Nations and the Statute of International Court of Justice, International Court of Justice cannot assume jurisdiction over a state automatically. International Court of Justice can assume jurisdiction only when the states have consented to it. And the consent of the particular state while submitting itself before International Court of Justice can be assessed only when it has submitted a declaration under Article 36 para 1 or under Article 36 para 2 of Statute of ICJ. China has not given its consent of International Court of Justice under Article 36 para 2. That means it is not a signatory to the compulsory jurisdiction of International Court of Justice. And we must understand that in spite of the presence of the word compulsory under Article 36 para 2 of International Court of Justice, It is not compulsory jurisdiction. The classical form of compulsory jurisdiction has not been exercised. You can have jurisdiction only when a particular country has signed a declaration and deposited before the Registrar of International Court of Justice. As far as Article 36, Para 2, where International Court of Justice can assume jurisdiction over a member state, such sort of declaration is absent as far as China is concerned. So if one country approaches International Court of Justice and seeks redressal of the law that I've just mentioned, International Court of Justice cannot assume automatic jurisdiction over China because China has not consented to the jurisdiction of ICJ under Article 36, Para 2. England is the only permanent member of Security Council that has deposited a declaration under Article 36, Para 2. Rest, France, USA, USSR, China, none of them have submitted a declaration under Article 36, Para 2 of the Statute of ICJ. So, as far as contentious jurisdiction of International Court of Justice is concerned, it's very difficult to say whether International Court of Justice has jurisdiction over China. So, what option do we have? There is one option that is available before us, and that is the advisory jurisdiction of International Court of Justice. Now, what is advisory jurisdiction of International Court of Justice? It is prescribed under Article 96 of the Charter of United Nations. Now, advisory jurisdiction, this is a method that International Court of Justice has borrowed from the Permanent Court of International Justice, is its predecessor. Now, what happens that the Covenant of League of Nations and Charter of United Nations are trying to solve the dispute between the two members states through peaceful settlement of dispute or through the political means. But at times, a situation may arise. At times, a situation may arise where any political situation might comprise of certain legal elements. So, as far as a legal point is concerned, some of the organs of the Charter of United Nations can approach the International Court of Justice and seek the advice over that question of law. Now, what are those organizations that can approach the International Court of Justice for its advisory jurisdiction? It is the General Assembly and Security Council. Security Council has approached International Court of Justice only once, and that is in the Namibia case way back in the 1970s. General Assembly itself can approach the advisory jurisdiction of ICJ, or it can authorize any of the subservient organs or any other main organ of the Charter of United Nations. It can authorize any of the remaining 5 main organs, or it can authorize any subsidiary organ uh, of the Charter of United Nations. So, since the World Health Organization is one of the subsidiary organs of the Charter of United Nations, it has been authorized by the General Assembly through a declaration to approach the International Court of Justice for advisory opinion. And World Health Organization did approach International Court of Justice in the year 1996 in the famous legality of nuclear weapons, but the situation could not be solved as World Health Organization did not have the power to refer such a question because it is not dealing with the nuclear laws. So the World Health Organization can approach International Court of Justice whether China has violated Article 6, Article 7 of the International Health Regulations, or whether it has violated Article 18, Article 64, Article 18 of VCLT 1969, Article 63 and 64 of WHO Constitution. And what will be the validity of such an advisory jurisdiction? Advisory jurisdiction can be is given for 2 reasons: for a question of law and for question of fact. Now, as far as question of law is concerned, advisory jurisdiction is binding on the parties who have approached the World Health, International Court of Justice. And there is one more catch to it. There's one more catch to the World Health or to the International Court of Justice advisory jurisdiction, that whatever advisory jurisdiction is given by International Court of Justice under Article 96, with the advent of time, it becomes a source of law because it becomes a part of customary law. So many of the decisions given by International Court of Justice have now assumed a status of international law. We can take the example of the reparations case. We can take the example of the first admission case and the legality of use of nuclear weapons case. These are the three advisory judgments or the advisory jurisdiction cases of International Court of Justice, which today have become a part of source of law. It is now a part and parcel of customary law. So by invoking the advisory jurisdiction of International Court of Justice, member states can create a customary law as to when a country can be held accountable for the outbreak of a particular pandemic. Now, this was my assessment of the relation of international law and coronavirus. Now, if we go on to see as to what changes coronavirus can bring in the international relations. Now, I'm not going to assess the political situation of each and every country, and I'm not going to discuss whether the superpowers like USA and European Union and China have been brought to their knees, or the days of the superpowers are over, or we are seeing the waning effect of US and European Union. That remains to be seen, because most of the arguments that are happening, or most of the discussions that we are happening, they're not happening for a fact. We can only assess the situation. What we can see, or what we can anticipate in the future, is the pandemic like this is going to create certain radical changes in the conceptual understanding of international politics and international relations. So I'm only dealing with the conceptual changes that may happen in the future. Now, when I say conceptual changes, I'm only going to deal with certain abstract concepts that have defined our understanding of international relations and international politics so far, and how these traditional concepts can be changed with the outbreak of the coronavirus. Now, if we look at the first concept, something that is called hard power, soft power. Now, Joseph Nye, the famous political scientist, he was of the view that in international politics, powers can be of two types: the hard power or the soft power. Hard power can be seen with the example of USA and USSR and China and Israel and other countries. So, hard power is a country which is trying to flex its muscles by showing its military might. Whichever country has the biggest or the most powerful military in the world is automatically considered to be the strongest one. Now, to counter this, Joseph Nye came up with a term called soft power. Now, a soft power is not flexing its muscles on the base of its military might. It is not, a soft power is not continuing the strategy of domination. It is pursuing the strategy of coordination. It is not creating a sense of fear in the eyes of all the other political actors. It is trying to create a culture of acceptance, a culture of sensitivity. So, soft power is a particular country which is trying to sell its story to the world. It is attracting people towards it. It's not dominating, it is attracting people towards it through its culture, through democracy, through rule of law, through its compliance with human rights, through its tolerance, and through its unity and integrity. So, if you read Joseph Nye's work, then there are two countries which have so far perfectly molded themselves into the idea of soft power, and that is Japan and Germany. Now, since 2004, a new term has been brought into being called smart power. Smart power is a combination of hard power and soft power. A smart power is a country which is trying to sell its story through its culture, and militarily it is not that weak, but at the same time it is technologically advanced. Its main reliance is on science and technology. So considering the outbreak of coronavirus, I think in the future the yardstick for measuring the strength of a country will move beyond the bipolarity of the soft power and the hard power, and the way will be given to this soft power, a nation state that is not only militarily strong, is not only culturally strong, but is receptive to international organizations, that is in a better position, that is in a position to quickly respond to epidemics and pandemics and to save its population. And again, a big situation, a big change that we are going to see is that we are going to see a more active role being played by international organizations. Now, so far, states and the concept of sovereignty has dominated the scenario of international relations, international politics, and international law. Now, with the outbreak of pandemic, I think in the future we are going to move towards a world government, or in other words, I'm going to use a technical word, we are going to move towards an era of supranationalism, a world system where states will have to surrender a major chunk of their sovereignty to international organizations, and the future government will not act in isolation. It will not be a government working within its defined territory without the interference or without the technological know-how of international organization. So in the future, international organizations are going to become an active part of our municipal law. That's the way I see it. The international organization being integrated into a national system, or in a way, we are going to see the internationalization of constitutional law, because as we can see that whatever measures are being taken, the social distancing, isolation, quarantine, or vaccination, as I've already mentioned, all this is coming from the international law. So the future, or the future world, or the future international order will not be dominated by state. It will very much be facilitated by international organization, and we are going to see a vast change in the way things work. And I think in the near future, this artificial dichotomy of national and international law is going to end very soon, because it's not only about internationalization, it is not about globalization, it is about mutual protection of humanity. So the future world order will not exclusively belong to state. It will not exclusively be governed by the power of sovereignty. It will be more cooperative, more universal, more receptive, and more pluralistic in nature. And in my assessment, the international legal order, international political order that we are going to see in future will be dominated by those countries who have been able to fend off the pandemic in a better manner, because not only have they shown grit, or not only have they shown integrity, they have also shown a lot of courage. And I think the balance of power is going to change. The balance of power is going to shift from USA, Russia, and China. I think we should invite more people into the realm of balance of power, and we should invite responsible and responsive states like Germany, Canada, New Zealand, all those countries who put the lives of their citizens first. As we have seen, particularly Germany and New Zealand, they put the lives of the citizens first. They are more concerned with the lives of the citizens rather than parochial politics or nonsensical melodrama that we are seeing all over the world. So it is better to have a plan and to execute it. So that was my assessment, a brief assessment of the two themes that I had to discuss with you: the impact of coronavirus on international law and its impact on contemporary international politics. I hope I was as forthcoming as I could be, and thanks to listening to me. And I would like to thank the Department of Law and Lucknow University for giving me this wonderful opportunity. Thank you.
Shishir, you are not audible to us.
Thank you, Bhanu sir, for this wonderful informative session and clearing all the nuances regarding the impact of COVID-19 and on the international law. And
Thank
now I welcome co-convener Haji Dubey to welcome Professor R.K. Verma.
Dear participants, we have among us Professor R.K. Singh, former head and dean, Faculty of Law, Lucknow University. Sir, please kindly grace us with your prudence.
Hello, am I audible
Good
to all
evening,
of
sir.
you?
Yes, sir, audible.
Yes, sir. Good evening, sir.
Good evening, Bhanu. I'm listening just 5 minutes before, and you are delivering a very wonderful lecture. First of all, I would like to
Thank you,
thank
sir.
the organizer for organizing this wonderful webinar topic impact of COVID-19 on international law. So it is one of the wonderful effort which we have made by all of you, and for this act of this whole events, I'd like to congratulate all of you. I don't know who is organized this event, but Saksham Agarwal told me. So first of all, I would like to congratulate the team of Saksham Agarwal and some other persons, those who are directly and indirectly involved to organize this whole webinar. As far as my own assessment is concerned, as I know very well that Dr. Bhanu is one of the great expert over the international affairs and international law. So I hope he has already covered all the aspect of the international law over the corona impact. But but still, I believe it that as far as the corona issue is concerned, as we are all aware of this fact that corona doesn't see international border. Each and every country of the world now this time is facing the very difficult era of time. And if you see the post corona effect on the international organization, so on this front, I believe it that there is a lot of critical issue involved after the post corona impact. There are so many organizations. I think it is my personal opinion, though I am not very much expert of the international affairs. But to the best of my little knowledge, I believe it that after the corona impact, now the existence of the United Nations as well as the existence of the UE, I think European Union, along with the WHO, I don't think that there is any existence after the post-corona effect, because if you see just like Security Council are now working in जैसे कि आप different organization could relay what the functioning of the WHO now this time. There are so many international leaders have already blamed over the functioning of the WHO, its role over the control over the corona. And as you are already aware of this fact that President Donald Trump has been time and again raised the issue of the corona impact by the WHO. So I think that time has come when we have to think about the role of UN and WHO and so many other international organizations, because whether they are really achieve their objective for which they have been formed, the very important issue is there here. Whether the world will act together, remain under a post corona, is also not clear. The role of each and every country of the world in order to fight the corona is also not be very much clear. Each and every country of the world are now facing the corona impact by their own efforts. I don't think that all the country of the world are united over the issue of the corona. अगर आप देखें डोनाल्ड ट्रंप को देखें, हमारे प्राइम मिनिस्टर साहब को देखें, ये सभी अपने अपने देश में कोरोना को रोकने के लिए जो भी इनसे इन्फेक्ट हो रहा है वो ही कर रहे हैं. Every country of the world are now inventing and exploring their own possibility to fight the corona, to control over the corona. क्या एक यूनिवर्सल एफर्ट नहीं हो सकता है कि सारे कंट्रीज मिलकर इस पैंडेमिक को रोकने का एक एक सार्थक कदम उठाएं? इफ यू सी द ड्यूरिंग द टाइम ऑफ द कोरोना कोई भी ऐसा सम्मेलन नहीं हुआ इंटरनेशनल लेवल पर जिससे ये कहा जा सके कि ऑल द कंट्री ऑफ द वर्ल्ड आर यूनाइटेड टू फाइट अगेंस्ट द कोरोना. What would be meaning of all these things? It means that every country of the world are now realizing that they have to fight the impact of the corona by its own effort. No country of the world will come and assist to us. मैं टीवी देख रहा था, मुझे मैंने एक डॉक्यूमेंट्री टेलीकास्ट देखा था कि यूई जो है यूरोपियन जो यूनियन है जिसमें कि सारे यूरोपियन कंट्रीज के ज्यादातर लोग उसमें सदस्य हैं, फ्रांस, इटली एंड जर्मनी एंड ऑल दिस कंट्री आर फेसिंग a very grave threat of their own countries. They are demanding the EU to give some assistance so that they could fight the corona. But the EU has denied by saying that we have no our own fund so that we could provide it. What it means that if the country of the world are not, if the any country of the world, if the any country of the world are not protecting their own citizens, so what would be meaning of the bilateral and multilateral treaties? क्यों यूई बनाएंगे लोग? क्यों यूनाइटेड नेशन का सदस्य बनना चाहेंगे? क्यों WHO का सदस्य बनना चाहेंगे जब they fail to provided any kind of the protection to any nation of the world? So what would be the existence of all these things? I think that Bhanu is the right person to maybe highlight of all these issues. कि वो क्या होगा इन ऑर्गेनाइजेशन का after the post corona issue? I fail to understand right now. So I hope that it is my little observation over the issue of the corona, and I believe it that कि after the post corona all the country of the world should come forward, try to unitedly fight and try to unitedly face the issue of the corona. क्योंकि हर कंट्री आप देखिए जितने भी डेवलप कंट्री हैं, दे आर नाउ फेसिंग द प्रॉब्लम ऑफ अनएम्प्लॉयमेंट, दे आर नाउ फेसिंग द प्रॉब्लम ऑफ इकोनॉमिक uncertainty, they are facing the problem of health sectors, industrial sectors and all these sectors. क्या ऐसे में जो जब कंट्री खुद ही उन तमाम तरह के प्रॉब्लम फेस कर रही है, वैसे स्थिति में क्या वो दूसरे कंट्रीज को साथ लेकर चलना चाहेंगे, खासकर डेवलप कंट्रीज? It is the issue which very soon will highlight the matters in upcoming time. क्या अनएम्प्लॉयमेंट जो फेस कर रही है, अमेरिका आज सबसे ज्यादा अनएम्प्लॉयमेंट की प्रॉब्लम फेस कर रहा है. क्या दूसरे नेशंस के सिटीजन्स को वो अपने यहाँ एम्प्लॉयमेंट देना पसंद करेगा? और अगर नहीं, then what will be the impact of this whole issues over the international arena? So it is the issues which now we going to face by the international communities. चाहे वो एम्प्लॉयमेंट का एस्पेक्ट हो, चाहे वो इंडस्ट्री का एस्पेक्ट हो, चाहे वो कोई भी टीटीज हो, बायलैटरल टीसीज हो, मल्टीलेटरल टीटीज हो, इन सभी टीटीज का क्या इफेक्ट होगा? क्योंकि जब यूएनओ बना था, इसका एकमात्र पर्पज ये था कि वर्ल्ड वार को रोके, युद्ध को रोके, तमाम तरह की चीजें। At that time, no one was realized that the day will definitely come when one virus will make a lot of effect over the whole international communities. तो इसको रोकने के लिए क्या यूएन का एक कोई अलग से कोई प्रस्ताव आएगा? क्या रोल है सिक्योरिटी काउंसिल का इन ऑर्डर टू फाइट द कम्बेट ऑफ कोविड-19? क्या सिक्योरिटी काउंसिल हाथ पर हाथ धरे बैठे रहेगा, देखता रहेगा ये सभी चीजों को? As far as the issue of the China is also a very complex issue. All the countries of the world are now raising the finger against the China for the spread of corona. So what would be the role of China, and how the all the countries of the world will take the issue of the China, by individually, by collectively? It is the matter which will definitely be seen in upcoming time. So I hope all these things will raise a very definitely a very serious issue in upcoming time. Whether the world is ready to face this kind of the challenges, और अगर ऐसा होगा, हर एक कंट्री अगर इंडिविजुअली इस प्रॉब्लम को फेस करेगी, इस चैलेंज को फेस करेगी, कोई एक यूनिफॉर्म या मॉडल बायलेटरल ट्रीटीज नहीं होगी इस पोस्ट कोरोना को इम्पैक्ट को रोकने के लिए, या पोस्ट कोरोना के जो इफेक्ट है इसको साइडलाइन करने के लिए. So I think that it is my personal opinion that in upcoming time it would be a very difficult time for the international relations between each and every country of the world, because the corona has eroded every country from its roots. तो इन सभी परिस्थितियों को देखते हुए आने वाले समय में आई थिंक दैट द टाइम विल बी डेफिनेटली tough for every country of the world. And the one, I think, there would be only one motto should be that is the mutual cooperation by each and every of the country of the world, so that we could fight against the corona. So it is my little you can say that view over the post corona issue. Thank you very much, Bhanu.
Now I would like to
Hello.
welcome. Now I would like to welcome Mr. Saksham Agarwal for vote of thanks.
Hello. I am watching
Thank you, sir.
Saksham. How are you?
Thank Ji.
Can I
Fine, sir.
talk to
Fine.
the Bhanu? Can I talk to the Bhanu?
Yes,
Yes,
sir. Yes, sir.
Thank you.
yes, sir.
Thank
Sir.
you. Thank
Can
you,
I
sir,
talk
for
to the
your
Bhanu?
kind
Bhanu is
words.
here.
Good evening, sir.
Bhanu, could you make
Good evening,
some
sir.
statement over by this whole statement?
Sir, I have covered the situation of China, and I was just discussing about the future of international law.
What would be the future of WHO, United Nations, and Security Council
Sir, as
after
far
the
as
post-corona issue?
yeah, yes,
Do
sir.
you,
So one
do you think
aspect.
that do you think that these organizations should come forward, try to play their vital role in order to organize all these things?
Huh. Sir, I was discussing because the entire because while I was delivering the lecture, the words like isolation, quarantine, and social distancing, we must understand that all these words are coming from international law. And if we look at the international health regulations, Article 1 and the various articles that we can see, international law is trying its best to prevent the situation. In fact, it is international law that is providing the solution for finding for fighting the pandemic. So in the future, I think as Ronald Dworkin had said, taking right seriously, I think the Indian universities and our educational system should start taking international law seriously. And we must understand that the future lies that when the national countries should devoid themselves of their power battles and start realizing that when the time comes, in times of war, in times of pandemics, it is international law which is more effective than constitutional law. And as far as the future of World Health Organization is concerned, World Health Organization has incorporated most of the law related to pandemics, but where it lacks, it's its enforcement part. It's not an enforcing, or it's not very hyperactive as compared to Security Council. So even if the laws of the Constitution of World Health Organization is not followed, or if international health regulations are not followed, the treaty as such has not provided for a sanction mechanism. So I think in the WHO Constitution and international health regulation, we should have a viable sanction mechanism. And so, as far as the Security Council is concerned, the role of Security Council, sir, unfortunately, is very limited in the case of a pandemic, because its role is limited by virtue of Article 24. Its main duty is for the maintenance of international peace and security. And this international peace of security, by virtue of the Charter of United Nations, is primarily kicks in whenever there is a situation of war. What Security Council can do is, by invoking Article 29, it can create new subsidiary bodies who can provide aid and assistance to the member states. But for that, national countries must learn to cooperate with international law. We must learn to cooperate with World Health Organization and takes the measures seriously. And for that, we'll have to dedicate a large chunk of our budget on the
Right.
health of our citizens.
Right.
And so
One
as
issue,
far as
Bhanu,
yes,
yes, yes, Banu, one issue definitely I would like to also highlight here, that what would be happen if the developed countries are totally stopped to provide funding to these international organizations? Because as I heard from so many sources that tomorrow it would be possible that so many developed countries of the world, just like Germany, France, America, and so many other countries, they are now planning to stop the funding of the
yes,
WHO as so many other international organizations. And if
yes.
it is so, then what would be
Hmm.
impact of these whole organizations, including the UN also?
So, so far, US had threatened to stop the funding of World Health Organization, but a number of countries, they offset this threat by contributing more to the World Health Organization. The situation of not funding a particular organization, this is a typical feature of American foreign policy. It has been done before, and most importantly, it is always followed by a president who's coming from a Republican party. So funding has always been an issue. So either we create a world sovereign fund which will be completely independent of the power of its member states, because the same situation that is faced by World Health Organization is also faced by United Nation Organization. So in addition of having its independent state, maybe it should have an autonomous banking body that can be done, because funding is a
Okay,
major issue. So I think
right.
that can be a hypothetical solution. World sovereign fund, a world and international organization fund, completely out of the reach of the member states and exclusively within the control of the officials of World Health Organization or any other international organization. As far as the situation of China is concerned, the best legal option that we have today is the advisory jurisdiction of ICJ. Because if you're going to invoke the contentious jurisdiction under Article 36, Para 2, China has not given its consent under Article 36, Para 2, and
Definitely,
ICJ
definitely.
cannot assume its jurisdiction automatically. So, interestingly, some of the lawyers of United States of America have sued China in their domestic jurisdiction. Class representation suits have been filed in Florida, Nevada, and California, and these lawyers have sued the American government amounting to $60 trillion. So the total damage that has now been claimed till today, even as we speak, is somewhere around $250 trillion. So that has been done under Foreign Immunity Act. Although it's not a very wise step, and most of the cases that have been filed are liable to be rejected by the U.S. Circuit Court. But this is a step that has been taken by some of the U.S. lawyers, although it's not very legally sound. But yes, this is one step that has been taken.
Okay, Bhanu. Okay, thank you, Bhanu.
Thank you so much, sir. Thank you so much. Saksham, you're not visible.
Thank you, sir, for this session, and I thank you all the participants for this 3 day event, and they are being with us.
Now we should